Don't punch him. Do not punch him. He's not allowed to enter. Open his door. He's not allowed to enter. You cannot enter my apartment, officer. He don't live here.
Yes,
She does. She has the right to go in.
I put them in a mason jar and I put them in the fridge next to the eggs. The cost of the surgery to extract the testicles was $20,000.
Yeah, so you didn't pay that. The state paid that.
The state valued them so much, they paid 20 grand to get them out.
So let me ask you this, was the conversation ever from you, I'm done with you, could you please get your testicles out of my refrigerator?
The whole purpose of her having her balls is to create discomfort in other people.
In regards to Dee's nuts, Brianna D. Kingsley's nuts, I wanted them back. They are priceless. The damages were the loss of these nuts.
Here. Today? Today?
Yes.
Okay. Just checking.
Yes, Your Honor.
Yes, need to move things out of my way first. Yes, you guys can stay right there while we're doing that. Let me try to get some of these other people home for dinner. Pines of Clover Lane versus Juan Brown, but counsel, I will be breaking when never mind right now. Kingsley.
Thank you.
State your appearances, please.
Afternoon, Your Honor. Attorney Andrew Babnick on behalf of the plaintiff who is appearing here as well.
Name, please.
Brianna Kingsley.
All right. And where are we on this case, folks?
Your Honor, we've had a few hearings on this. The court had set this for a trial at this point based on the affirmative defenses that were asserted in the matter. I believe there's no triable issue. If you look at the answer filed by Ms. Kingsley in the matter, she admits to the non-payment of rent. She admits to the fact that there are damages to the unit. The court is aware there were police reports filed and attached with the complaint that the damages were the result of the defendant herself breaking the windows, refusing access. The landlord is now going to be outside of the certificate of occupancy that was issued because repairs can't be made. They can't get access to the property. It continues to deteriorate. As a result, there's a broken window, broken doors on the interior, broken doors on the exterior. We filed a notice to have this terminated as a result of the health and safety hazard, as well as the non-payment of rent, and we'd be asking for a judgment at this time.
Response.
I had it prepared here. I will pull it up. Okay, this was what I received from attorney with the legal aid, Tracy Jensen. And there are several issues at hand, including procedural defenses. In regards to my written statement and the statements made by Attorney Babnick, the property is not damaged. The pictures that the landlord included, I have countered and included pictures of the house in its current condition. The house was inspected by the Ypsilanti Building Code, Miss Jamaica Berry, in October. In October, I also filed a formal complaint with the city of Ypsilanti through the C-Click Fix notification system, a governmental agency, of the issues with the habitability of the home. I have filed a case with the Fair Housing Administration. There are many things that we could focus on. I would like to focus on the fact that I was denied a disabled parking spot. And according to Michigan Legislature Section 600. And that is 600.5720 says that if it's an alleged termination was intended primarily as a penalty for the defendant's attempt to secure or enforce rights under the lease or agreement or under laws of state, governmental subdivision, or United States, they denied my handicap parking. I filed several complaints at the city level, and I'm defending myself here. The alleged termination, part B, was intended primarily as a penalty for the defendant's complaint to the governmental authority with a report of the plaintiff's violation of a health or safety code or ordinance. The allegations made by the landlord, I wanted to bring in a third-party perspective. So I contacted the Cincinnati Building Code Department. Mr. Jamaica came out and did an inspection and found 12 violations on the landlord's at the landlord's responsibility. In regards to the statement by Attorney Bagnick that they have not been allowed to access the unit, that is so false. Her husband, Mitch Carrick, busted down the door, and I was not able to secure the unit.
This isn't the time for me to receive.
I think there are tribal issues, and I can.
Thank you.
Yes,
that's
sir.
all you needed to tell me. And when I look at that, then what I'm going to do is I'm going to do two things today. I'm going to set it for a final settlement conference on this. We'll hash out specifically what issues are going to be litigated. The parties are going to need to be ready to go to trial when I set the trial date at thereafter. All right. I'm also going to order regarding escrow, and I'm just going to say this to you, Ms. Kingsley, that you coming into court and posting escrow in $1 bills, this court views as just harassing my clerks and making my clerks go through that process. It is something that I'm not going to tolerate. There is no reason why you have to bring single dollar bills in. You did that when you paid the $111.11. You also did that when you paid $444.44, which my clerks had to count out. You also did that when you paid today the $666.66. So on my own motion, I'm going to order that as you post escrow, that you may only post escrow in denominations of US currency, not less than $10 bills. It is further ordered that from you on this case, because of your abuse of the process, and my clerk's office are ordered that they are ordered to accept no $1 or $5 denominations of US currency for you for the purposes of escrow. And I have signed that order. We will present that to both parties. See everybody on March 19th.
Questions from the court? What's the rest of the court as far as the escrow?
There is a $111.11 posted by our records. It was posted on January 8th, 2024. On January 10th, 2024, there was posted $780. On January 22nd, 2024, there was posted $1.11. On February 5th, 2024, there was posted $444.44. And I think today, correct?
Yes.
Today, there was posted $666.66.
If I may, Your Honor,
Go ahead.
I just want to establish that I paid the full amount through February, and there is a balance ready for March. This is not an issue of paying the rent.
My issue isn't with whether or not you pay rent. It isn't anything like that. You will not be trying to bring singles in, trying to make some point to my clerks. They have nothing to do with whatever the issues are here. They are here trying to serve the public. You will not hand them $600 worth of $1 bills for them to count out. It just won't happen. and I've issued that order.
Would you like any response to that, or we can just move forward?
You can make whatever response you want. I'm just telling you, don't bring any singles in here trying to post escrow. Don't bring any $5 bills trying to post escrow. $10 or higher.
Understood.
That's it.
Going forward, Your Honor.
Is there an adjourned date, Your Honor? I'm sorry, I didn't know.
March 19th, 2024, 9 a.m. in person.
Your Honor, if I may continue,
Thank you, Your Honor.
if I may.
Go ahead.
Right, so I did confirm with the clerk that all US accepted. Policy does not-
No longer on this case. That
Yes,
is my order. Thank you. I'm done.
We are done. Thank you, Your Honor. I understand. March 19th at what time?
9 a.m.
Thank you, Your Honor. Have a wonderful afternoon.
I will do. You do the same.
I will do my best. I am grateful.
Lines of Clover Lane versus Juan Brown.
Good afternoon, Judge. Carrie Zanin, P 67390 on behalf of plaintiff.
Juan Brown? You haven't checked it. No. You solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do. Your Honor, plaintiff, at this time, this is second or a third hearing. Plaintiff moves for default judgment, rent to retain $6,014.67, court costs of $176.04 for a total rent retain of $6,190.71. Asking for possession, a writ issue date of February 26th of 2024, and I have a judgment prepared. May I get your
Judgment to the plaintiff, that is by default for possession. Redemption amounts in the amount requested, the writ issue in 10 days. You, madam, seem to get a lot of enjoyment out of that, didn't you? No, you're the smirk on your face. No, yes.
I always.
Yes, no,
I
I noticed a smirk, and so did Alan.
Oh, Judge, actually, I
I'm
always
just-
get called after one of the ones that.
I'm just.
You know it's right, because I saw the look on your face.
Yeah.
I just always get lucky, Judge.
And some days it's just not worth it. Court claims at Clover Lane versus Ann Cano.
I'll get it.
Hey, Judge. Good afternoon. Bri Kingsley, attorney.
There we go.
Happy New Year. All right. I think the last time I was here, I was supposed to get a written answer. Did you get that filed?
This one's great.
That available. I went to legal aid, to have them review what I prepared for you. They weren't able to get me in. So this is what I have available today for the written statement.
No.
I have the
Yeah.
executive summary in one page,
Executive summary of what?
of the circumstance. You asked for a written statement. I have one.
No. Okay. What I asked for you to file is a written answer. That's under the court rule. I need to have a written answer to the complaint in a format that the court rule provides, which means you have to answer the complaint paragraph by paragraph. And you have to lay that out and attach whatever exhibits you are to it. A copy of that answer then has to be provided to plaintiff's counsel.
Thank you for educating me on the process.
Okay.
As I said, I have this prepared. I was gonna have it reviewed by Miss Tanya over at Legal Aid.
So this lady, she's smarter than this. I mean, she plays dumb, but I promise you, she's just trying to get another extension. You can see in the lawyer's face, look at him. He's just like, oh man, she's totally playing us. She's totally playing us. But the judge knows it too. But I think he's bound by some rules where it's like, okay, she's self-representing her. She's self-representing, and he has to give her some leeway. But once he says like, this is the last one, if you come next time with any excuse and ignorance is not going to be an excuse that's going to follow. It's actually, ignorance is not even supposed to be an excuse one time when you self-represent yourself. Wait, that didn't make sense. Self-represent yourself when you're self-represent. So, but she plays them like a fiddle. Then she does like this mental health thing, and but yeah, let's watch it.
See, I saw her on
Sorry for
Wednesday. She
interrupting.
told me come back on Thursday. I came back on Thursday and they were too busy to take me in. This is what I have, sir.
Okay, all right. I'm sure over the holidays.
World's smallest violin.
Your Honor, as a reminder, I know the court's hands are tied here. This is the third hearing on this file. I've got rent, late fees, and court costs up to $5,300 at this stage. And as the court may remember, there was originally a file filed by my client improper that I had dismissed and refiled to make sure notice was proper. So this has been dragging on for some period of time.
No, I know. I hear you.
Right.
Here's what I'm going to do. I'm going to adjourn this out 2 weeks. You need to get that corrected. It has to be in proper form for the court. Counsel for the plaintiff needs a copy of whatever you file with the court.
Before the next appearance.
Well, I want it filed by the 12th. I want it filed within a week. I'm going to adjourn this out 2 weeks because counsel for the plaintiff is going to have an opportunity to look at it, and I'm going to need an opportunity to look at whatever you're filing.
Yes, Your Honor.
I am not going to take any excuses if it's not here. If it's not here, I'm going to presume there is no answer and I'm going to issue a default. Because I've given you this is the second time I've given you to go around outside of what happened in the last case. You follow me?
I apparently I didn't. My impression was that I was to show up with a written answer, and that's what I've done.
No, I have your written answer. Your written answer was due by January 2nd.
Where is that listed, sir?
It's right in my file. I wrote the note. I do it all the time.
May I have someone point that out to me? I'm supposed to say the third. Does it appear on there?
Those are my handwritten notes right on the ROA. Written answer, January 2nd, 2024.
May I have a copy of that, sir?
You can get a copy at the clerk's office. I'm not providing you a copy of anything. I ordered it on the record, and that's when it was supposed to be here. Even if you believe that it was today, that's not an answer, and plaintiff's counsel doesn't have it. So I'm making it very specific. You will provide a written answer in conformity with the Michigan court rules. You will do that no later than close of business on January 12th, 2024.
Yes, sir, I will.
Your Honor, is the court able to order escrows at this time? Rent is continuing to be due.
I can order escrow. What is the monthly rent?
$980, Your Honor.
That's disputed, Your Honor.
Okay, but I'm going to order escrow in that amount. Can you prorate that on a 30-day for me? Yeah.
So here's the proof that she's doesn't want to pay it. And she's using these tactics to not pay it because she's not even willing to put her rent into escrow, which is, the court holds it. But you guys all know that if you're law nerds like me, once the court holds it, and then at the end of the judgment, whoever wins gets the money. It's usually the landlord.
Sir, they failed to provide a safe housing. He locked me out.
Okay, but listen. 980.
980, okay.
Well, hold on. 980. What's my prorate for January?
Well, it's $33 a day.
Okay.
I may, Your Honor.
Say what? Escrow is ordered in the amount of $858. That's a prorated amount for January. And then in the amount of $980 thereafter. That must be paid 7 days within the date that rent is ordinarily due. Plaintiff's counsel will prepare an escrow order for signing by the court. To that effect, yes.
The ledger, the schedule provided by the plaintiff is not GAAP compliant. It does not show the total amount paid per month by who. It is an insufficient form. And I have all that here. I have a response, sir, that I think is relevant to whether the escrow starts now or in the future, because
Ma'am,
I have copy, for example, if I just may share this part. The Ypsilanti building inspector came and found 12 violations against them, not against me.
the escrow needs to be paid. I will take that into consideration in terms of any counterclaim or other thing that you're filing. But in terms of the escrow, that's what I'm ordering.
Okay, so Ms. Mills, my caseworker at MISTA, said that I applied for state emergency relief help for the eviction when it originally started back in October. And was told that the landlord must provide a statement. The statement that they provided to the court wouldn't pass any accounting 101 course, sir. It does not show the proper.
For what? They needed to provide a statement for what?
May I hear your question again, Your Honor?
They needed to provide a statement for what? What
This
was
is
the
what I'm
purpose
referring
of
to,
the statement?
About how much rent is owed, the amount that they're claiming, the fact that they broke the lease, like their response
Okay,
that they
but-
sent has a schedule on it, sir. And I think the court would find it insufficient. I cannot defend myself against vague allegations and incorrect math.
The math ultimately becomes incorrect. That will be straightened out. But right now, I'm ordering escrow in the amount of $980 per month, prorated amount for January in the amount of $858. When you go speak with legal services, certainly they can tell you how to ask this court to reconsider that order. But that's what I'm ordering at this point.
Understood?
Your Honor, the 858, would you like to within 7 days of the order?
Pardon?
You would
Yes,
like
payment within 7 days of the order.
What happens when I'm unable to pay because I'm indigent and disabled and fixed income? I cannot pay 980. I never did. I paid half of that with a roommate they allowed to break the lease. What?
Okay.
I have
Here's,
everything here, but you don't
Oh.
want to see it.
sir, ma'am, that's not what I'm saying. I need it in the form. Oh, you're gonna turn your back on.
Yes, sir, because you disrespected me right now and
Okay.
I'm vulnerable in the court system.
She's like turned her
All right.
chair around.
Ma'am, first of all, so that the record is clear,
That's
I have not
badass.
disrespected you in,
You just did. I hear you say, well, things that you said was, I'm ready when you are. Ma'am,
ma'am,
it doesn't feel good, does it, sir?
ma'am, don't try to play that with me.
Yeah.
I deal with that with students all of the time. I sometimes will make a mistake, but you are not going to have me feel guilty because of that. So if you wish, if you want to make that an issue, then you make that an issue. That is not my true thoughts. Answer by January 12th, 2024, close of business as indicated on the record. We'll see everybody January 19th,
What was the time? of the 19th?
2020. Pardon?
I didn't hear the time for the 19th, Your Honor. You may have.
January 19th at 10 a.m.
Thank you, Your Honor.
Thank you, folks.
I'm gonna tell you guys right now that January 19th is gonna be super live because there's like 6 updates that are gonna happen from today that are vicious on January 19th. I put it in my phone, a reminder, and a reminder and an alarm to make sure that I'm live and ready on January 19th. Make sure that I take that time off from my other 2 jobs.
How do I look? What you look at? Now,
What do you want a copy of?
what you just ordered, what wasn't clear last time. I left here thinking that I'm supposed to come up with a written statement, which I've done and you've denied without looking at, right? I just want to know what I'm supposed to do because it is not clear.
You have to file an answer.
And when you say answer, it needs to be a specific form. What form number, sir?
You have to go and find those. There, you can go to the Supreme Court website. There's a general form of an answer. But I have to have the answer filed in compliance with the Michigan court rules. All right, that's the first thing. And I need that by the 12th. You told me that you're in contact with legal services, correct?
I've met with them once and.
Okay.
This week, yes, sir. That's
Right, so what you need to do, and what I had indicated, is get back to them. They'll be able to assist you to make sure that it's in the proper form. All right? Have attachments to all of those and file that with the court, as well as send that to plaintiff's counsel. All right?
Yes, sir, Your Honor.
And then the other thing is, I've ordered escrow. Counsel for the plaintiff is going to be preparing that so that that order will be there. You will get a copy of that order.
Yes, sir.
And that's basically it. And then
May I have that in writing before I leave? How do I get that in writing? I have memory issues. I'm disabled and I've already made the court aware of this. I need it in writing.
counsel for the plaintiff, will you please prepare an order submitted under the 7-day rule to the court, please?
She's full of it. Now she's claiming memory issues, but she can remember all those numbers and details, and like the math doesn't add up. And she claims that they couldn't even take accounting 101 or wouldn't pass accounting 101, but judge gave her specific instructions to write that response like he always does. He never does not say it. But she didn't understand that. Like I said, it's a ploy. Some of these defendants, I feel for. Some of them, I just know they're deadbeats, and they're just. But I get it. Times are hard. But I mean, right or wrong, honesty is always the best thing to do. In my life, I've fallen short on that, and I try to just be a better person every day. When it comes to integrity and shame and guilt, like just even like white lies on a text, I find myself just backing up because it festers shame, it stimulates shame, and then shame turns to guilt, and then it's all downhill from there. So integrity is just huge. I'm discovering or learning this past decade. But okay, sorry.
Yeah, sure.
For everything that I ordered, that way there will be written communication.
Yeah, sure.
I'm done. Thank you.
Not a problem, Your Honor.
Court calls the case of the.
You over?
Good day, madam.
I will. Thank you.
She called him ma'am.
Look real cute.
As do you.
Wow.
I realized, like, give me 5 minutes, please. Court stands in recess.
He's done. I'm gonna fast forward this 5 minutes. Yeah, he's over that. That's crazy.
Eric Zorica, I'm sorry, versus Bri Kingsley.
Good morning, Your Honor, or afternoon, Your Honor. Attorney Andrew Batnick on behalf of the plaintiff.
Bri Kingsley. Oh, there you are.
Morning, Your Honor.
Good afternoon.
Oh, no, no.
It's okay. The last hearing I had a total amount of $35.73 owing. Is that where we are still?
Your Honor, we found an additional $490 when there was a request for a ledger for monies owed. It seems that Ms. Kingsley had always paid digitally. She had paid my client directly through, I think this is probably Cash App. She asked for a refund and they processed a refund of $490. So an additional $490 is owed on that prior amount.
Okay, so what's the total amount you're claiming?
So it is $3,430 in rent, $450 in late fees, $183 in court costs, which is a total of $4,063.
And do I have a response to that?
My response is, the accounting that I received from the landlord does, I have not received a refund of $490 that they claim. I checked my accounts, it has not come to me. Additionally, the accounting was not complete. They showed my payment history, and I am the co-lessee with A. Begovich. There is no payment history from my former roommate.
Well, usually the payment history is by unit.
And that's not what I received, sir. May I share with you what I received from them?
Let me see it.
Yes, sir.
And Your Honor, so the court is aware at the last hearing, the defendant told the court he had not paid, or she had not paid September, October, or I'm sorry, October, November, and December's rent. That's already on the record.
I don't understand the 490 chargeback.
So I'm not sure what the court may be looking at, but if it was my cover letter from December 15th, it included the attachments. There is what the court will see in the attachments, the last 2 pages, you will see the verification that the 490 was initially received, and then a second verification that 490 is being refunded through the Cash App. It was requested by the defendant and has been pulled back from my client's account.
Okay.
I would ask the court, or I can inquire of the defendant, if she did request a refund. I know she says she didn't receive it, but she didn't state whether she requested one through the app.
Did you request a refund?
I did talk to my bank about some fraudulent activity on my account, and this was one of my concerns because I've communicated exclusively through Mr. Carrick. Mr. Milovan goes by Mitch, but all the paperwork's from Zorka, so I was not certain who the actual owner was. As I said, I have not received the refund, and I can show that if that's helpful.
No, not at this point. I mean, the absence of something isn't going to necessarily help me. All right. So you did, I recall at the last hearing, indicate that you did owe those other months.
At the last hearing, I indicated that I have stopped paying because they have failed to maintain a safe unit.
All right, here's what I'm going to do. Go ahead.
Yes, sir. Thank you. I have a copy of an inspection report from Ypsilanti Building Inspection Officer, Ms. Jamaica Berry. When they first attempted to accuse me of destroying the property, I thought it would be helpful to get a third-party inspection by the city. Ms. Berry found 12 violations on the landlord's behalf, did not find that I had caused any damage. I have that full report to submit into evidence.
All right, well,
And I have,
hang on, I'm not going to take evidence at this point. It looks like first thing that I'm going to need is a written answer from you as to this complaint.
okay,
So I need a written answer by 1 week out. Can you do that?
1 week out with the holidays, can we make it first of the year?
All right, written answer by January 2nd.
Thank you.
2024. I will adjourn this matter then out to January 5th, 2024 at 2 p.m. And then we'll see where we are. With that written answer, you have to file a copy with the court and you have to send a copy to council.
Does that have to be officially heard or just to the council contact?
To council, you can send it via email to him or however you need to get that communicated.
Thank you for your attention today, Your Honor.
Thank you.
Your Honor, any escrow order for the rents being paid, or are we holding off here? 'Cause my guy is still not receiving rent, unfortunately.
Let me see. Well, this was set December 15th. We're at the 22nd. Under the new court rule, I can't order escrow at this point. It has to be 14 days.
Okay, so we'll have to deal with that on the 5th.
Yes.
If I may say,
Your Honor, last
Honor.
question. I'm still traveling on the 5th. I could resubmit another request, but I didn't know if a request to have myself heard.
Yes, you can submit another request.
Okay, thank you, Your Honor.
Thank you. And yes, ma'am, you had another.
I did, and then it just lost me. I have receipts for the repairs that I've made to the unit in regards to escrow. I heard that I don't have to start the escrow now. My attempt so far, what I've done, I've already worked with Mishta, but because the landlord had previously failed to give me an accounting date, and I paid.
Ma'am,
on that.
You'll need to supply that in your answer.
Got it.
And then I can take whatever need to into account regarding escrow. Okay, thank you.
Happy holidays.
Lakestone Apartments. Lakestone Apartments.